So we are going to do 5 questions on Section 319 CRPC. We all have gone through the Bare Act and we have seen that Section 309 empowers the court to summon any person as an accused who is not named there in the charge sheet. So that is a special power of the court. We have already seen what's there in the Bare Act. Now we are going to see 5 questions. Question number 1, and these questions were raised in the recent case of Manjeet Singh versus State of Haryana. So that is the occasion I am discussing these questions with you. What is the stage at which power under Section 319 CRPC can be exercised? So the first question relates to the stage. When can the court exercise the power under Section 319 CRPC? The second question, whether the word evidence used in Section 319, subsection 1, could only mean evidence tested by cross-examination, or the court can exercise the power even on the basis of the statement made in examination in chief of the witness concerned. Now we all know that when a party calls his or her own witnesses and examines them, then this is called examination in chief. After that, the other party, the opposite party, is given an opportunity to cross-examine those witnesses. So after cross-examination, the evidence is tested, right? The deposition made by the witnesses during the examination in chief get tested, right? So before cross-examination, only the examination in chief has taken place or it's going on. Can the court exercise the power of Section 319 CRPC? Can the court summon a person as an accused, add a person as an accused who has not been named in the charge sheet or whose name does not even appear in the FIR? So can it be done before cross-examination, or the court has to wait till the cross-examination is over? So we are going to answer this question. The third question is whether the word evidence used in Section 319 subsection 1 CRPC has been used in a comprehensive sense. Comprehensive sense here signifies that whether this evidence includes all the materials collected during investigation, all the materials. Now it may be noted here that when an investigating agency completes its investigation, it may not produce all the materials before the court, or it may decide not to produce certain materials because they are either not relevant or they do not have much weight, whatever. So even those materials should also be included, or only those that have been filed before the court at the time of charge sheeting, right? So we have to see the word evidence is used in comprehensive sense, that is including the materials, all the materials brought by the investigating agency during investigation, or only those materials that have been produced before the court that have been brought on record. Fourth question is, what is the nature of the satisfaction required to invoke the power under Section 319 CRPC? Whether the power under Section 319 can be exercised only if the court is satisfied that the accused summoned will in all likelihood be convicted. So I am simplifying this question. Does the court have the power to summon an accused under Section 319 only when the court is almost sure that such an accused will be convicted, or there is maximum probability, there is high degree of likelihood, there is high degree of probability that he will be convicted, or mere suspicion that such accused may have been involved and must be tried is also enough? So we will see whether at this stage the court will really do an appreciation of the evidence in order to find out whether there is a strong probability of that other person to be convicted. Only then he should be summoned as an accused. Only then the power of Section 319 must be used. And the fifth and the last question, does the power under Section 319 CRPC extend to persons not named in the FIR, or not named in the FIR but charged but not charged, but named in the FIR but not charged, or who have been discharged? We know that the court may discharge some accused persons before framing of charge. So, can the court, while exercising its power under Section 319, summon a person who has been discharged by the same court earlier, or against whom a closer report has been filed by the police, or whose name is there in the FIR, but the name does not appear in the charge sheet? Maybe the police officers did not find that person to be accused, or did not have enough materials to move against him, or the person who has not been even named in the FIR, means his name also does not appear in the FIR. Can such a person also be summoned as an accused? Wide Section 319 CRPC. So we are going to answer all these questions in various points. These are points directly taken from Manjeet Singh State of Haryana case. It's 2021, just 6 days ago it was published. So the first thing that we are going to see, Section 319 CRPC springs out of the doctrine judex damnata cum nocens absolvita. This is a Latin maxim, and it means a judge is condemned when guilty is accused. Means it is the pious duty of the judge to see that the perpetrator of crime should not be absolved, should not escape the clutches of the law. He must be punished. Sometimes some persons are so resourceful that they may manipulate the investigating agencies also. And by such manipulation, they may escape. So where it appears to the judge during the trial that some person has been left out by the investigating agency, but he seems to have committed the offense, or there are strong evidences to suggest his involvement, then he must be brought to the books, he must be brought to justice. So a judge is condemned, he is the bad judge when the guilty is accused. So it is this duty, this is pious obligation that underlines Section 319 CRPC. So the first point, this is directly lifted from the judgment. While exercising the powers under Section 319 CRPC and to summon the persons not charge sheeted, the entire effort of the court is not to allow the real perpetrator of an offense to get away unpunished. So this is the pious obligation of the court. The court must ensure that even if a person has not been charge sheeted, but there is a possibility of his involvement, then he must not go unpunished. He must be brought, he must face the trial, so that the real culprits must be incarcerated or must be appropriately punished. Second point, where the investigation agency, for any reason, does not array one of the real culprits, for any reason, can be bribe, corruption, nepotism, whatever, right? There are various reasons, or the investigating agency was not investigating properly, it wasn't focusing on the case, its diverted attention may have been the reason, or maybe the investigating agency was manipulated, was influenced by the accused, who is a resourceful person. So for any reason, if the investigating agency does not array one of the real culprits as an accused, does not charge sheet, the court is not powerless in calling the said accused to face trial. So the court has the power to call that person and face the trial. Section 319 CRPC allows the court to proceed against any person who is not an accused in a case before it. This is a very plain sentence, very simple sentence, no need of explanation. So we are getting our answers, 5 questions that were raised in this case, Manjeet Singh case. We are answering those 5 questions one by one. So in section 319, the court has the power against any person who is not an accused. Section 319 CRPC is an enabling provision, means it empowers the court, gives the court the power to do something, to take appropriate steps for proceeding against any person not being an accused, for also having committed the offense under trial. The power under 319 can be exercised at any stage after the charge sheet. So at what stage, this is one of our questions, at what stage this power can be exercised? So this power can be exercised at any stage after the charge sheet and before the culmination of the trial, before the trial ends, before the denouement of the trial, right? So this is the whole period. At the end of the trial, we know the judgment comes and the trial begins as soon as charge sheet is filed. So after charge sheet and before the completion of the trial, at any stage between these two particular points, right? So at any stage after the charge sheet is filed and before the pronouncement of judgment, but not at the stage of sections 207, 208 CRPC. Why? Because if you check your Bare Act, you will see this is the stage of committal. Committal means where the subordinate judge, that is, he may be metropolitan magistrate or judicial magistrate, commits the case to the superior court, that is the sessions court, right? So this is the stage of committal, and the Supreme Court has held that at this stage, the judge who is doing this committal is only an administrator, right? He is more an administrator than a judge. At that stage, he does not apply his judicial mind, right? So it's a ministerial thing that he is doing. So this is pre-trial stage. So since this is pre-trial stage, here the power of section 319 cannot be used by the magistrate, right? So except during the stage of 207, 208 CRPC, that is the committal stage, which is only a pre-trial stage intended to put the process into motion. We all are aware of the stage of committal, where the magistrate commits the trial, commits the whole case to the superior court, that is the sessions court here. The court can exercise the power under 319 CRPC only after the trial proceeds and commences with the recording of the evidence. So as soon as the evidence begins, as soon as the recording of the evidence begins, the judge gets empowered, right? And he can exercise this power at any stage. So even at the stage of examination in chief, even when the examination in chief has not been completed or examination in chief has been completed, some witnesses have been examined, some witnesses are yet to be examined, even at that stage. The word evidence in section 319 CRPC means only such evidence as is made before the court. So the answer is clear. Our question is answered. The materials, all the materials that were collected during investigation will not be included in the definition of evidence here. Here, evidence means only those depositions or documents brought before the court when the trial has begun. So evidence made before the court in relation to statements and the documents, obviously. So only those evidences will be considered to be evidences under 319 that are made before the court. So obviously, from charge sheet till the stage of judgment, whatever is brought before the court through the witnesses, right, through examination in chief, through cross-examination, through documents, only those evidences will be the evidences to be taken into consideration by the judge for exercising his power under section 319, not other materials. It is only such evidence that can be taken into account by the magistrate or the court to decide whether the power under 319 is to be exercised, and not on the basis of material collected during the investigation. So answer has been given. If the magistrate or court is convinced, even on the basis of evidence appearing in examination in chief, it can exercise the power under 319 and can proceed against such person or persons. That the magistrate is convinced, even on the basis of evidence appearing in examination in chief, powers under 319 CRPC can be exercised. This is a reiteration, but we have to assert, we have to emphasize sometimes to bring things to home. The power under 319 can be exercised even at the stage of completion of examination in chief, and the court need not wait till the said evidence is tested on cross-examination. So well and good. if the judge waits till the time of cross-examination. But he is not bound to wait. He can exercise his power under 390 even at the stage of examination in chief. Even in a case where the stage of giving opportunity to the complainant to file a protest petition, urging upon the trial to summon other persons, as well as who were named in FIR but not implicated in the charge sheet has gone, in that case also the court is still not powerless. Now here, a little bit of explanation is required. We all know that after the charge sheet is filed, the complainant may come to the court with a protest petition, right? He may make an application under section 173 subsection 8 and may accuse the investigating agency of bad investigation, of erroneous investigation. The complainant may insist that certain persons have been dropped out or certain persons have not even been named in the charge sheet, right? Even though the complainant had named them in the FIR, but the investigating agency did not do complete investigation, did not do the investigation properly, or maybe the charge sheet was filed hurriedly sometimes because the 60-day deadline or 90-day deadline under section 167 may ruin the prospects of the investigating agencies. So sometimes they hasten up, right? That they have to file charge sheet as quickly as possible. And for that, they do not do proper investigation. So where proper investigation has not been done, every complainant has the right to come with a protest petition and to make an application under section 173 subsection 8 so that the court invokes its power to order further investigation. This expression further investigation is mentioned there in 173 subsection 8, right? So suppose that stage has already passed and even the complainant did not bring a protest petition. So the complainant has not brought the protest petition. The complainant did not point out at that time, right, when the charge sheet was filed, right? Maybe he kept on sleeping. But when the same complainant at any stage after this, after the charge sheet is filed, makes an application under section 319, the court may consider the application and the court may even go to the extent of summoning the named person, of summoning the accused, if the court is convinced on the basis of the depositions made before the court during the examination in chief. So if it is satisfied, here the court cannot say that why didn't you come with a protest petition initially when the charge sheet was filed and a copy of charge sheet was given to you. The court will not say that why didn't you raise hue and cry at that time? Why didn't you ring the bell then? No, even at this stage. So here, even where the stage of giving opportunity to the complainant to file a protest petition, urging upon the court to summon other persons as well who were named in the FIR but not implicated in the charge sheet has gone. In that case also, the court is still not powerless by virtue of 319. So even where there is no protest petition and only an application under 319 has been made by the complainant, the court has the power. If the court is convinced, if the court is satisfied that the persons named in the application are involved or are concerned, then the court may summon them as an accused. And even those persons named in the FIR but not implicated in the charge sheet can be summoned to face the trial, provided during the trial some evidence surfaces against the proposed accused. So the condition is the court must be satisfied on the basis of some evidence against that named person whose name was there in the FIR but not charge sheeted, but during the course of trial some evidences have surfaced. Now let me tell you here the court will depend upon the depositions only. This is not the stage of appreciation of evidence. This is not the stage of weighing the evidence. That will be done later. Here, if a witness has named XYZ, if another witness has also named XYZ, this may be enough for the court to summon that person as an accused. Here at this stage, the court will not go into the merits of the depositions because This is not the stage where the merits must be appreciated. That is, during the trial, the things will be tested. Right now, at the stage of 319, the court will not go into the merits. The court will only go into the facts brought before the court, the evidences brought before the court. Now, these evidences may be false evidences. Later, it may turn out that it is a false evidence. These evidences may be fabricated ones. These evidences may not be best pieces of evidences. That is not the concern here. This is not the stage where the merit will be examined, right? So, some evidence surfaces against the proposed accused, maybe in the form of examination in chief of the prosecution witnesses. While exercising the powers under section 319 CrPC, the court is not required and not justified also in appreciating the deposition, in appreciating the evidence of the prosecution witnesses on merits. Why? Because this is the matter of trial, right? This is 319. Here, the court has stopped the trial for a while and is considering the 319 application, or is considering application of exercise of the power of 319, where it has some evidences against persons who have not been charge sheeted, or even the persons who have not been named in the FIR. So here he will only see the quantity and not the quality of evidence. The quality of evidence will be seen little later. Let the person come and face the trial. So this is all about section 319, right? We have considered 5 questions. These questions were raised in Manjeet Singh versus State of Haryana case decided recently in 2021. And that is why I found this as an occasion to discuss the points that were raised there by the Supreme Court. And the Supreme Court itself has answered these questions. So I hope we have all the answers to the questions now.